Hi, everyone. Harry here to talk about the potential mischief that Judge Aileen Cannon can wreak on the prosecution. I have an op-ed on this that lays it out in further detail at the LA Times, where I, kind of count the ways, 5 different concrete ways that she can really, really gum up the works. Let me cut to the chase on getting rid of her because it matters, and I think I'm more doubtful than others have been. There's a statute that instructs her to step aside if her impartiality could reasonably be questioned. It really seems to me completely obvious that based on her misadventure with Trump before, her being slapped around and reversed for really not just, bad judgment calls, but shoddy legal reasoning and getting involved in the first place. She was, very harshly upbraided by the 11th Circuit. That said, the law on recusal is tough, and the Department of Justice practices on recusal is narrow. The law basically requires under the leading case, what happened was a district court judge was ordered to do a certain sentence and just refused. And when it came up to the Court of Appeals, they said, you're out. Here, Cannon had grievously wrong opinions. But the department often makes the distinction, if that holds, and they're trying to play it by the book, between bad rulings and actual bias or potential worries about impartiality. And of course, moving to recuse Cannon if it doesn't work, that's something that has harsh implications for a litigant, going into court and taking the judge and taking the shot at bringing her down and being wrong potentially could just embolden her and alienate her. So let me say that I'm less sanguine than many of my esteemed colleagues that they can get her out. Nevertheless, I've called for her to step down on her own. I've said, I think this is right. There are 700 plus district court judges in the country. She's the number one, heads and shoulders above any other in terms of the need for her to step down, lest the public believe that things aren't impartial. You might think it would just be smart of her anyway. Why does she need all this trouble and scrutiny and likely even bigger hits on her abysmal reputation? But last time, it didn't stop her from doubling down. And I think, you can cross your fingers. I am crossing my fingers. But if she doesn't take herself out, probably the department waits for more mistaken rulings on her part that are appealable. Big, important concept now that we're at trial, whether something can be pushed up to the Court of Appeals before a trial has happened or only after, then you might see it. But I'm swallowing very hard and assuming Judge Cannon is with us. So I've laid out several things. There are more, but let's just start. She can really mess up on jury selection. You have this normal drill where one side or another wants a juror to sit because the juror has said, I like Trump a lot, or I despise him. And then the party that wants that juror to sit says, but couldn't you put aside your views and fairly apply the law? And 9 times out of 10, the juror says yes. And at that point, it's, an argument in front of the judge in which one side, let's say it's the DOJ would say, Judge, come on, you heard this is not someone who is really going to be impartial and unfair. And the Trump side says, Judge, you heard from your own questions that she loves Donald Trump, but she can set it aside. That goes to the district court. She has a lot of discretion, so she can seat 1 or 2 or 3 or 4 jurors who are super strong Trump. Now, the record in the country today has been pretty good on that. We've had a couple trials that included at least one strong Trumpista who nevertheless, she, in one case, he in another, put aside their prejudice. But voir dire, man, it's big. Generally, delay, delay, delay. We know that that's Trump's playbook. And we know he wants to put this off until after the election, when if he wins, he can just make it go away. Um, it shouldn't happen. It really shouldn't happen. Whatever you feel about Donald Trump, the American people deserve the ability to go to vote for him or against him, knowing if he's a convicted felon on these serious charges. If the trial is not till after November 2024, nearly a year and a half away, they won't have that chance. And a judge like Cannon could easily put things off and make the delay pronounced enough that we're not talking about even a trial before the election. She has a lot of discretion about these things, and she's going to be hit definitely with motions from Trump to try to delay, including maybe out of the box. I have new counsel now. They need a few months to get up to speed and the like. So delay is the big one. Evidentiary rulings. It's a very interesting dynamic in trial. Prosecutors are used to it. A lot of judges will kind of lean toward defendants in evidence rulings because if they're wrong, it's unlikely to come up on appeal. If the defendant is acquitted, it becomes double jeopardy and won't be retried. So the United States can't really raise a beef. And if the defendant is convicted, well, they're not going to raise a ruling that was good for them. So evidentiary rulings, even an honest, straight-up judge might well kind of lean in a certain way. Cannon could really lean, and the number one thing I'm thinking about is Evan Corcoran's notes, which, as I've said before, are almost the star witness here. There are ways in which she could really curb or preclude their use, starting with just revisiting the issue and saying, yeah, I know another court said there was crime fraud here, so it's not attorney-client. I disagree. It is attorney-client. They're out. Man, would that hurt. They're really important documents. Okay, so those are the three big ones. Then jury instructions. There's final showdowns where sides want different versions of important instructions, even as simple as what does beyond a reasonable doubt mean, but also evidence anchored in the case itself. It's the district court that decides this. It's usually the stakes are high, and it's a final conference before closing argument where the two sides argue the word smithing issues. Cannon could really do some big harm here and give the jury the decisions to make on the facts under law that is really tendentious. And again, if it's unlikely to be able to be appealed, because if he's acquitted, no appeal. And if he's convicted, he wouldn't be objecting to these rulings. The United States could, of course, but, if they convict, they won't. They could maybe try things if there's a hung jury. So delay, number one, the evidentiary motions, especially Corcoran. Number two, well, in time, jury selection, jury instructions, and then of course sentencing, a whole nother ball of wax. So one way of thinking about the case is it is overwhelming on the facts, and those will be presented to a 12-person jury, and that's what really matters, and it is. But a district court judge, and Aileen Cannon in particular, can still really make it an uphill climb for the prosecution, maybe even almost trim their sails so much that they don't have a strong case anymore. And Aileen Cannon is just the person to potentially do it. As I end my op-ed, we'll drop a little cite of it in case you want to look. 700 district court judges in the country. She is the first whose impartiality might reasonably be questioned. She should recuse herself, or she should be taken off the case. But it's not at all clear that it will happen. In fact, I think the betting odds are now against it. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.